Good afternoon, everybody. A very welcome to you all, and if possible, even more to Bruno De Pauw. Hello, Bruno. Thank you for coming over. For those people who do not know Bruno De Pauw, I'm sure that every Belgian person that is attending knows who Bruno is. He's really in Belgium, without exaggeration, the top specialist in international social security. And he's very well in explaining things. If necessary, he can talk all afternoon, but he will limit himself to 1 hour to talk to you about what are the consequences of working at home in an international context. Bruno, you have the floor for 1 hour only, Bruno, but after that, you will have all the time to ask questions. You already can ask questions during the presentation, and if you see a very interesting question, you can add it to the question that you think it's interesting, and it will come up, and then we will ask the question even during presentation. Bruno likes to have an interaction with you all, so do not hesitate to ask questions, and we will get into it immediately. So I hope it will be interesting. I'm pretty sure it will be interesting. The floor is yours.
Welcome, ladies and gentlemen, and thank you, Inge, for this introduction, which puts no pressure on me whatsoever. But let's immediately enter the topic, remote working in an international context. Now, is it an issue? Question is it worthwhile to speak about it? Well, when we have a question, what do? We turn to the internet, and more specifically, the social media. Of course, this is professional, this is not Facebook. So we have a look at, you probably recognize it, LinkedIn. And here, this is what I recently found a few days ago, a classical example. I'll give you a moment here to read it. And in fact, what is it? It's a typical example of the nowadays way of getting work done, result driven. And here the boss says, as long as the work gets done, I don't mind whether you work whatever hour and from the office or from the South Pole. I hired a job. 22,000 people said yes, very well, thumbs up, etc. So clearly it's a question of result-driven work and wherever you want. And of course, then you have the consultancy. And recently I found this very nice announcement by PwC USA. You can work from home, from wherever, forever. So clearly 46,000 people liked this post. So clearly we can deduct from LinkedIn that it's an issue, it's a thing. What about working cross-border? Now, is it a good thing? Of course it's a good thing, provided, and here comes the important point, you know all the consequences from changing the workplace, and secondly, you're willing as an employer and an employee to assume the consequences of your new workplace. Now, cross-border working, of course, has multiple aspects, like, for example, labor law, salary levels, working hours, etc. Then there's a very important issue of tax law, of income tax, and then there's social security coverage. For example, what happens during an accident at work, even if it's sitting behind your laptop. Now, for labor law, it's possible that the legislation of one state applies or even multiple states at the same time. Tax law, classical situation, you can have a split situation. For social security, it's very easy. It's like a monotheistic religion. It is, there shall only be one. There's always one state that is competent. For elderly people like me, they of course immediately thinking about the movie Highlander. Now, what are we talking about? Which words are we using? And often it's telework, Teletravail, telewerk. It's in fact where you're working, but there can be many forms of telework. Sometimes it's called remote working. It can be working from home, say. It can be working in a hub or co-working space. And then you have the young digital nomads who roam the world with their laptop and work literally from any place. All this is under the general issue of remote working or telework, not just from home then. But let's make sure we start on the right foot. And the right foot in Social Security is the place of work. You know, from the Belgian, European, international rules, Social Security is always linked to the place of work. And what is the place of work during telework? Well, it's very easy because it's not an open question. It's a question that has been answered about 10 years ago by the European Court of Justice in a case called Partena or Les Tartes de Chaumont-Gistou. And it was about location of the activity. It concerns a certain Mr. Rombots who in fact managed his own company, which was a Belgian company in Belgium, from his home in Portugal. And the question was, is this working in Portugal? Is this working in Belgium? Is this working on both territories? Because there was a Belgian internal legislation that says, if you manage a company which is subject to the company tax in Belgium, you are deemed to work, in fact, in Belgium. So there was a legal fiction. The Court of Justice was very easy and they said, what is the place of work? Look at the normal language and more specifically, the place where you carry out your activities. Or in other words, as you see, it's the physical presence in the territory of a state during the exercise of professional activities. Which means a remote worker, the workplace is the place where he is physically present during the work behind his laptop or whatever. So there's no fiction as if he were still working at the office. A very important point for all the next items to follow. Let's go back in time, before anybody heard of Corona or COVID-19, business as usual. Because the question is, what are we talking about? Are we talking about a marginal quantity of people or a lot of people? Now, in general, there was an enormous lack of data. But the data I found here, which is more or less okay, it's Eurostat data from the year 2019 and about frontier workers. So people residing in a member state and working in another member state. So it's not like tax law in the zone, but wherever in the country. And there was an estimate, so it's underestimate in my opinion, of about 2 million people. Here on the slide, you see the main places of work, so where people work, often the company was situated, and residence, it was where these people resided. A few numbers, but this was before everything changed with Corona. Now, I start by insulting your knowledge and your intelligence, if you let me, with a short recap of the rules. I'm aware that 99% of you will be very familiar with the rules, but still, just to make sure we're on the same page. Most important point is a group of companies, of countries, is in fact a European economical area, which is a European Union plus Iceland, Liechtenstein, and Norway, and Switzerland. Because there is one set of rules, it's the European coordinating regulations. You see the number on the screen. The principle is they implement the basic cornerstone of the European Union, being the free movement of persons and services in order to attain the single market. For these European rules to apply, you need at least 2 states of the European Economical Area or Switzerland to be involved. If everything is within one state, then it's purely national law, it's not European law. This European piece of legislation determines which member state is fully competent exclusively. So one and nobody else. And a series of conflict rules is used. Conflict rules, a number of rules which attach this competence of the unique state to a certain event in a state, like working there, employer there, residing there, etc. And those rules, which make a state competent, take priority, overrule the national rules. Otherwise, for example, in Belgium, nobody would be covered. Right, these rules, these conflict rules, a bit more in detail, but very little detail. You work in one state, basic rule, and I permit myself a bit of Latin because all European colleagues do so. It's the lex loci laboris, the law of the place where you work. A main exception to this rule is the posting, also called detachment or secondment, which means a temporary mission abroad where a number of conditions are fulfilled, and then you keep your habitual social security scheme in your backpack during your mission abroad. Second set of rules is for people working on the territory of different member states. Multi-state working. There's a rule for one employer, there's a rule for multiple employers, there's a rule for mixed qualifications, being salaried worker, self-employed worker, etc. But to keep things simple, in general, it's the one employer rule. And what you see here on the screen, what is very important, if you work multi-state, so habitually, regularly, normally, your territory is not limited to one state, but different states. There we're going to look at the place of residence, the habitual residence, specific criterion for social security, and the working time. If your working time there is equal to or more than 25%, it is the state of residence which is competent. If it's less, then it's a state where the employer is situated, which is competent. So very important to have a look at the pattern and to know exactly how much time will you work. For the 25%, there's also income, but if you have one employer, time and income will be proportional. So know exactly how much time will this person spend during the next 12 months in the future in his home state, because that will be the most essential criteria. We go a bit further, a bit more exotic, and this time you get a request from a person wanting to work in a faraway state, in the USA, in Canada, in Australia. Now, legally speaking, we know Belgium has concluded about 25 bilateral agreements with more faraway states. You see them colored here in green on the slides. Now, these bilateral social security agreements are not identical. They are all based more or less on the same template, but there are differences in each bilateral agreement. What I've shown here are the general rules we find in any agreement. And once again, conflict rules, working in one state, same thing, lex loci laboris, an exception, the posting. All right, simple. But for the rules on multi-state working, in quite a lot of these bilateral agreements, there is no rule for multi-state working. This means if you start to work multi-state, for example, half of your time in Brussels and half of your time in New York, the result will be the dual application of the lex loci laboris rule, and this will mean that you have a split coverage for the working days in Belgium, Belgian Social Security, for the working days in the USA, USA Social Security, even if you have one employer. If you have only one employer, which is now our case, and this situation is not expected to last more than 5 years, it is possible to use what I've called here part-time posting. In a sense, it's working in Belgium, it's 3 weeks in the USA, it's once again working in Belgium, it's 4 weeks in the USA, etc. And you don't have to apply for a posting form for each mission, but you can apply for one big posting, and it's a kind of intermittent posting thing, which is only possible if it's a bilateral agreement without specific article for multi-state working. And then we go even more exotic. Two, in fact, states we have no connection with. Let's say South Africa. Because there is no international instrument, both national legislations will apply, which means the Belgian national legislation and the legislation of the place of work, so where you are remotely working. Belgian legislation, once again, working in one state, we have a specific rule in Belgium for employees that says, if you are sent by your employer abroad to a non-agreement country, for a period not expecting to exceed 6 months, then you automatically remain covered in the classical employee scheme, provided that you do not choose for the specific overseas social security scheme. What exactly the overseas social security scheme is, I refer you to our website, which is www.socialsecurity.be, where you can find all the details on this practical site. And of course, as you know, as civil servants, we get a bonus by the number of clicks on our websites. Now, this is very nice. Somebody goes to telework from South Africa for 2 weeks. No problem. It's less than 6 months, so you remain covered into the Belgian scheme. But watch out, completely independently, the social security legislation of South Africa applies, and it's possible that those domestic rules also oblige a coverage into social security, which makes the Belgian employer liable in the South African scheme. Because there is no coordination, this means both legislation act completely independent from one from another. So be sure. Of course, in this situation, there's also another series of issues like immigration and work visa, etc., which you should not forget. As concerns somebody who goes back and forth, back and forth, back and forth to such an exotic country, know that after 2 months back in Belgium, the counter, so the 6 plus an extension with 6 months, is reset. Also be very aware, I've put it once again there, check the national legislation of this place of work. Right. Now, this was the introduction before COVID. Then comes March, already a year and a half ago. This whole mess starts. What happens during these COVID times? Well, there is something that has never been done. It's a kind of lockdown. It is forcing people to work from home. And then very soon, already at the 18th of March, the Belgian competent ministers decided that this forced working from home should have no impact on applicable legislation, or translated in a normal language, they should not switch from social security country because they are working on a different place, because it's not choice, it's an obligation. This has been applied from the 13th of March onward till the end of the measures. It has been extended several times, and how long will this apply? You see it in the next slide, but it's the end of this year, 31st of December of this year. And then the grace period will end. So as a company, you better be ready for the new reality. Now, this Belgian decision is swiftly followed by the European Commission at the end of the month. And there was a communication and a fact sheet. The communication said, well, the normal rules apply, but the fact sheet said, have a look at what happens in Belgium, France, Germany, and the Netherlands, because they have created a no impact policy. And this should be, in fact, a best practice. This then has been, this idea has been followed by several other member states, but in the Administrative Commission of December 2020, this was adopted by all member states. So that a change of working place due to the pandemic should not have an effect on the applicable legislation. This has then been extended in the session of June 2021, and this rule, no impact, is in fact applicable till the end of 2021. Yes, so you hear the sirens. It's in fact the wake-up call. There's a sense of urgency now to act, because this grace period ends irrevocably at the end of the year. Now, you've seen here many other member states have a similar approach, similar but not identical. Everybody shares the basic idea, should not have an impact. But how it should not have an impact, then it's very different. There are member states like Belgium, you will see, who say you don't have to do anything, no red tape, no whatsoever, do nothing, just continue to pay contributions in your habitual states. Some states, on the other hand, says we follow this principle, but you need an A1, Portugal, for example. Other states say, yes, okay, but you need a specific agreement, an individual agreement based on Article 16 of the regulation to achieve this goal. Cyprus, for example. So watch out in the European context. It depends a bit on the country where you're in. And even though everybody shares the same ideas, they apply it differently. Now, Belgium and the surrounding countries, the neighboring countries, all have adopted the same policy in a sense, you don't have to do anything. Automatically, we say, based on force majeure, which is the pandemic, we say, okay, wherever you want, we still keep the applicable legislation. For bilateral conventions, we conclude an agreement with the other states, because they do not fall under these European guidelines. Third states, in a sense, Belgian employer says, I'm recruiting a Ukrainian national, but he's stuck over there. We say, act as if this person already arrived in Belgium, and you can already declare him into the Belgian scheme. This policy, this no impact policy, watch out, is no obligation. If employer and employee prefer to follow the normal rules, they can, of course. It's not a change of the rules, it's something that has been added in order to enlighten a bit this whole situation. Now, practically speaking, some examples. Let's take the following case. One employer, and the habitual place of work of this person is the employer's office, but his residence is in a neighboring state. So it's a classical frontier worker. Now, this frontier worker now just 100% home office. First question that arises, is this a posting? If you temporarily switch your place of work, but you're still working logically on behalf of your employer, is this a posting? Are the conditions of Article 12.1, the posting article in the regulations, are they fulfilled? Well, as you see, there are 3 dots and a question mark. I can give you the answer, the Belgian answer of my institution, and it's very clear. Yes, of course, this is a posting. For us, it is fully a posting, and we are absolutely convinced that ad hoc, occasional telework in another member state, that this qualifies as a bona fide posting. But be warned, not everybody agrees. A number of member states says, no, this is not posting. As I've heard, Ireland and Sweden, for example. And the most important point, the juridical service of the European Commission is of the opinion that this occasional working remotely is not a posting. Yes, when I've read it, I said, this is not possible. Well, what is the argument that is invoked? Well, the argument is there is no business reason. It's not the employer that says, you go and work over there, but it's the employee that goes to the employer and says, please, can you allow me to work from that place? Well, our answer to these different situations is like François Mitterrand saying, et alors? What about it? This has nothing to do with Social Security, and the Social Security rules do not impose any business needs or service provision for a situation to be posted. So for us, this is a mix-up of, in fact, the Social Security rules and the rules on the provision of services, which do not enter into play here. So for us, it is an exclamation mark. Yes, this is a posting. After starting next year, you need a form, probably. This year, for us, it's no problem. Even it's a posting, you don't have to notify it to us. If, on the other hand, this person starts working what is now called hybrid form, partly at the office and partly from home, then, of course, normally the rule of the 25% applies. And if, yes, he starts working, for example, 2 days a week, it's 40%. In his home state, the Social Security switches. But not yet. Till the end of the year, you're safe. In a sense, the classical rule before, when he worked full-time at the office, is still applied, fictionally by force majeure. But when January next year, in these kinds of situations, the Social Security switches.
I can add that the audience fully agree with you on your standpoint with regard to the fact that they mix up things.
Okay, thank you very much. It's very comforting to know that we're not alone. But for us, no problem. We'll back you up if you have issues with other member states, and we're even willing to go have a little fight with the Commission. It's not the first time. Now, second classical situation, it's a new recruitment, because even during the pandemic, quite a lot of people were recruited. And what happens then? One employer, and the anticipated place of work is the employer's office, but our dear employee is stuck in his state of residence. But it's somebody who's not fresh out of school and somebody who can actually already start working or learning or meeting or whatever remotely. So this person starts already working. According to the normal rules, this is a lex loci laboris because he works in the other member state. He's never been covered in the member state where the employer is established, so it's not posting. Because one of the conditions for a posting is that this person must, during the month immediately prior to his mission abroad, be covered in the scheme of the sending state. If that happened to you now, no problem. You can already anticipate and make that a reality and already declare him, if it's a Belgian employer, into the Belgian Social Security. But watch out, new rules will apply. Right, before, during, and then of course the main challenge. What will happen after COVID-19? And for us, after COVID-19 means from the 1st of January 2022. Why did we take this date? Because in fact everybody can travel freely now. We wanted also to include in this period the necessary time for companies and persons to adjust to the new reality, create new policies, negotiate with unions, etc. So now you're in this period where the free movement is already more or less possible, but you need first a decent organization of all this international working. Well, I don't have to convince you, but I did some clipping that this whole period, this pandemic, has made an enormous change in people's heads. You see here some examples, and for example, the classical Belgian company Telenet. Voila, allows staff to work from home until at least the end of the year. Largest working from home experience in the bank. And even for Showpad, a new job has been created. head of remote work. So somebody in HR who's specialized in managing all this remote work. So there's always new opportunities. All this simply to illustrate the fact that remote work is here to stay. It's not business as usual, the pandemic special, and afterwards business as usual. There is a complete switch, a mind switch, which has occurred. And all the surveys I've read is that there is a very high demand for what is called hybrid working, meaning 1 to 3 days a week working from home. Of course, this is for certain types of work. Production laborer, of course, he cannot go and take his job and his materials and go home. It is in general for the knowledge intensive business services, education, banking, telecommunication, etc. So the people that have been able to work from home, in general, want to continue to do so. So, well, next year, consequences and choices. Because then we start to apply the normal conflict rules again. And in a number of cases, this will lead to a change of the competent social security state. This is not a small thing, because this implies, first of all, a whole mass of red tape, compliance, administration, organization, etc., for employers and employees. There will be a change in the net salary, of course, because the social security contributions will get higher or lower. And also the proportion between employer's part, employee part is very different from one state to another. For the person themselves, the extent which social security rights do they have, this will change. This will oblige companies to create a remote work policy. All right, very nice. But also, extremely important, a tracking tool of the whereabouts, because I'm doing this international job already for more than 25 years. And the one thing that has been constant in this 25 years is that companies do not know where their employees are, because their managers fly around the world, and as long as the secretary or the management assistant has booked the flights and the hotel, the HR service is not even aware where the people are. So often it's also a tracking thing. So you need to put on a policy and know exactly where these people are. For example, you've seen the 25% rule. Keep an eye on that, because it's not because you anticipate that it's going to be 20%. If at the end of the year it turns out to be 30%, then you get a retroactive switch of Social Security, which is even worse. So know exactly where your staff are. Now, let's have a look at some new working patterns. And let's start with Adelheid. Adelheid is employed by Volvo Gent, and she wants to work from home. She is doing administration, but her home is in the Netherlands. And she works now almost 4 days a week. Okay, but I want to keep working at home at least 2 days a week. The question is, she is going to the HR department saying, can I work 2 days a week? Yes, I want already to know it, because I have to anticipate, well, next year is not very far away. What are you going to say? Well, it's very clear. If the answer is okay, this implies 2 days a week in a 5 day a week, even though probably you're not very good at math, this is 40%. 40 is more than 25%. Switch to Social Security in the Netherlands, which can at first for a Belgian company be, yes, it's cheaper, but there's a lot of extra insurances, because, for example, in the Netherlands, if somebody falls ill, you have to pay their salary for 2 years, not 1 month, 2 years. And everybody takes an insurance against this risk. Also, pensions are very low, and everybody has then a second pillar insurance. You have to pay that as well. You cannot simply fire somebody, you have to go to the judge to fire somebody, etc. So, are you going to allow Adelheid to effectively work 2 days a week? Then there's Nikolai. And Nikolai moved to Belgium in 2018 to work for Telenet as an IT analyst. His family moved with him, but they do not quite manage to integrate here. And they say, we're going back or it's divorce. So Nikolai says, dear boss, dear HR manager, you see now I can work fully from home because that's what I did. But I'm planning to move my home and my family back to Romania. There's no issue, there's no borders, it's European Union. Do you allow me to work from Romania? And from time to time, I'll come back to Belgium for a meeting and assessments, etc. But basically, I am going to work in Romania. Are you going to allow this? Because indefinitely move to Romania means Romanian Social Security. Because it's clear that the habitual residence of this person will be over there and his working place. Are you willing to be confronted with Romanian administration? It's an important question. And then thirdly, we have Amber. And Amber is young and chirpy and wants to see the world. And she goes to her boss and say, I want to see the world during 4 months because I've always dreamt about a trip across the Nordic countries. And before I start marrying and settling down, etc., I want to do this. But no problem for the job. I will combine this with working. And I promise, we put that on paper, I will work remotely from wherever I am, a hotel room, a hostel, on Monday, Wednesday, and Friday during my 4-month trip. Are you, as an HR manager, what will you do? Are you going to allow this? Well, I would say yes, because in this time it will be, it's posting. Simple posting, Nordic countries, European Union, it's a posting. So I would say, Amber, you go for it. Nikolai and Adelheid, there will be some consequences if you allow this. And last but not least, we have Momo. And Momo comes originally from Morocco, and he still has more extended family in Morocco. And each year he goes to his extended family back in Morocco during July and August. And he normally takes unpaid leave for this. But this year he says, boss, I want to propose something else. I use 3 weeks of annual paid leave, and the rest from the time I will work from my grandmother's home in Morocco during the rest of the summer holidays. Do you agree? Are you going to let me work from over there? Here we add some other questions. From GDPR, outside European Union, what kind of job does he do? Is he working with sensitive data, etc.? What about, yes, okay, Morocco, we have a bilateral agreement. We could call it a posting, but there are specific rules for health insurance. What about accidents at work? He is Moroccan, still dual nationality, so immigration should be no problem, but there's quite a lot of other things to consider as well. But these are situations, I've not invented them, it's situations we also have. And even the last one, it's one of my colleagues. So even for us, civil servants, these kind of questions start popping up, and you need to think about this, and you need to apply a policy. What are you going to do? And perhaps you don't like the answers, the consequences. So what do you do if you do not like the consequences? Well, you can do 2 things. You can stick your head in the sand and hope nobody will notice. Or you can start lobbying, typically, and try to change the rules of the game. Aha! We now see a new world of working taking place, but the rules are still the old rules. So what do? Oh, very simple. We first try to adapt reality a bit. And now comes a very common question. It's not Social Security, it's labor law. So I'm not going to give you the answer, but I've asked it to already quite a number of competent people, and up till now I did not get a final answer. So I suppose probably the final answer will be for the courts to decide, unless some bright juridical mind has an answer. Now, you're a Belgian company, employ 50 people. 20 of them are residents in the Netherlands. 30 of them are residents in Belgium. Before COVID, everybody worked in Belgium at the office. Now everybody says, I want to work from home. How much do you want to work from home? 2 days a week. Okay, but 2 days a week from the Belgian residents, no problem. But 2 days a week from the Dutch residents switching to Dutch Social Security, that you don't like. So the question is, when drafting your remote work policy, can you put a clause in it saying the Belgians are allowed up to 2 days, the Dutch residents only a maximum of 1 day a week. 1 day a week, 20%. Is it possible to make a differentiation? Or you can be a bit more sly and indirect and say, we allow 2 days a week for everybody remotely working on Belgian territory. It's another way of putting it, but with the same result. Can you draft such a policy? Is this not a discrimination? So the first question is, are they objectively identical situations or objectively different situations? Is it a discrimination? And secondly, if it would be a discrimination, it's clearly an indirect discrimination. Indirect discriminations can be justified. Are all those consequences I've told you about, are they enough to justify such an indirect discrimination? For the moment, there's a question mark. I have my own opinion, but this is an official webinar. If we were in a cafe, I could give you my informal opinion, but I'm not going to do now, because it's not the competence of the National Social Security Office. But think about it. And of course, it's European rules. Adapt European rules. Well, it's very simple. No, not in any foreseeable time, because adapting the regulation, it's an enormously time-consuming process, and it's now already during 6 years and a half since the propositions from Marianne Thijssen. There was changes in the regulation, and it's still not adopted. So adapt the European regulations, not realistically in any time frame foreseeable. But there are more than one way to skin a cat. Because another way to have a new rule is saying 2 member states or more can conclude what is called an Article 16 framework agreement, which is an agreement not for individual persons, but they create a new rule. And if amongst each other they are agreed with a new rule, for example, in case of telework, it's only when you work more than 40% that the legislation will switch, something like that, and you publish it in your official gazettes, this is a new rule that applies. Is this realistically? Well, as I've surveyed a bit my foreign colleagues, they say no. We are not going to create a patchwork of all different rules. If the European rules will be adapted for remote work, it must be at European level, not at individual level between member states. And of course, there's always the classical escape clause, an individual Article 16 agreement. For this individual person who works 2 days a week in the Netherlands, we ask for an exception, a derogation, to make Belgian Social Security applicable. This means you have to go through us, and I can already give you the answer. The answer will be no, we are not going to do that, except for very specific circumstances. But our default answer will be, sorry, no.
Somebody mentioned this. Somebody mentioned us that in France, the French Senate opened the door to a test case of 2 working days at home per week with no consequences.
Yes, indeed, the French Senate did so, but the French Senate, of course, has nothing to do at European level, because the French Senate urged the government to start lobbying for this. Now, it is France. Well, what about it? Well, as you know, in the European Union, there's a presidency, a rotating presidency. Each block of 6 months, the presidency rotates. Nowadays, it's Slovenia, and from the 1st of January of next year, it is France. So, of course, this was an important point where the French Senate tried to put pressure on the, in fact, now new presidency, being France, in order, of course, to try to reach something. But one member state, even if they have the rotating presidency, they cannot change the rules. They can make some initiatives, but as people being more versed in European law will know, the start of any change of European legislation, it's the European Commission. It's the Commission that has to take the initiative for a proposal. In a sense, change your rule. And your rule, will it be only for remote work, or will you adapt the rules? And which percentage, etc. If you know it's been 6.5 years since the last proposition, and it's still not entering into force, so it's possible, it's very well possible, that this French presidency initiative may lead somewhere in the future to something. But we're talking about years in the future. You are now confronted with the date of the 1st of January. So it's possible that the European legislation will be adapted, but it's not for the foreseeable future, whatever the French Senate may say. We know in general there's a lot of pressure coming from France and from the Netherlands, also a bit from Luxembourg, but also in the Netherlands, they are in the process of drafting a legislation which is called Work Where You Want. And this legislation would create something new that exists in no other member states, the right for working at home. For the moment, it's still the employer in any member state that determines the place of work. And in fact, if he allows you another place of work, it's the employer's decision. There's no right for telework, remote working, or being digital native. And this might change with the Netherlands, but still it's just a Dutch legislation. As a resume a bit, because I've already been talking long, a bit of a block, a visual resume. First of all, you're confronted with the question for ad hoc telework. For us, this is a posting. Posting based on the European regulation. This is a posting based on the bilateral agreements, and this is a posting based on Belgian legislation. Secondly, you got a question from hybrid working, being partly at the office and partly somewhere else. In the European context, the social security of the country of habitual residence becomes competent. So if this hybrid working is from a holiday home, in France, for example, this person owns, then it's not much of a problem because his habitual residence will be Belgium and his temporary stay will be France. In a bilateral context, for example, USA, Canada, Australia, whatever, watch out because you are or in the situation of the split coverage or in the kind of intermittent posting thing. If this question, but it's not very probable, will be involving a country we have no agreement with, then I would say please don't start, because then you're really in for a very complicated situation. And to end with the classical question, I'm anticipating it because you will ask it, because it's something that we've always been asking. Yes, there is posting, there is multi-state, and then there's a whole issue of the A1. Now, is this burdensome, and I've used a very polite words, is this burdensome A1 form really needed in case of remote work? And of course, I will provide you with an answer to the question. And the answer is go and have a look at the legislation. And the European legislation is quite clear on this subject. In the implementing regulation 987/2009, there are the rules. And Article 15 concerns posting, and it says the employer or self-employed person shall inform, not may, shall, must inform the competent institution from the sending member states whenever possible in advance. Multi-state working, Article 16, the worker shall inform, must, obligation. In general, it's the employer that does it, but still. And it's the Article 19 that says only at the request of the person concerned or the employer, etc., an attestation being A1 form will be issued. Now, in general, in common language, these three articles are compressed into there is an obligation to request an A1. So this phrase is in fact three articles in one. So do you need, must, obligation, notify the competent institution of this cross-border work? The answer is yes. According to the rules, and if you want to comply, yes. Is there a sanction? Not in European law, but in a number of national legislation. So what would be my advice? It's a typical case of risk assessment. The effort to request an A1, which is very different in the different member states. For all the companies in Belgium, you are of course very lucky, because already since 2001, it's possible to request it online. And normally you get a form within 12 hours, 7 days a week. Very good news for if there were any French listeners, because in France, there has been a major change. So first, you had the Caisse Primaire d'Assurance Maladie. From next year, it will be one institution in France competent for legislation applicable, the URSSAF National. And this URSSAF National, and it's a guy called Bruno, that was smarter than the rest and said, oh, the Belgians have a very nice IT system. Let's, I would not say copy it, get inspiration. So they've been with us for a number of time to examine our online tools. They've created their own tools, which will be in force up and running in time. And I must say, from the demonstration I've seen, it looks absolutely excellent. I think it achieves the same level of swiftness and user-friendliness, etc., as we have. So also for A1s from France, it will be a breeze in the very near future to apply for these forms. On the other hand, if you're in Romania, well, you need a number of months. And I'm not talking about even UK, this special case or whatever, but in most member states, it takes quite an effort. Compliance, well, if you want to be absolutely compliant, it's very simple. Each and every time you request an A1. For all the other cases, I would say, why would you ask for a form? Knowing that the risk a social inspection will happen is zero, because you often will work in a private house, even a holiday home or whatever. First of all, I would say if you request one, you get legal certainty. If we issue you an A1 for a workation in Ireland, whatever the Irish interpretation of the rules, with our A1, you are absolutely sure it's Belgian and nothing but Belgian legislation. Certainty, it counts for something. Secondly, the two other cases are a bit less relevant for remote working, because often you need an A1 based on the contract clauses, subcontracting agreements. Often in the building industry, the clients will say, no A1, no work. typically for Belgium, but it exists in a number of other member states too, to counter the effect of certain national measures, like what is called in Belgium the 30 bis rule, or the withholding some of the invoice, and for example, building and the meat industry, etc. And last but not least, and I'm switching back to labor law, as you probably know, in the context of the Posting of Workers Directive, there is now an obligation to actually make a prior notification. In Belgium, it's called l'annonce. In French, it's called the SIPSI. And in the Netherlands, it's called the WAGWE, which is, I think, unpronounceable for non-Dutch speakers. But still, this is an obligation to make an electronic declaration for any form of temporary working on that member states. And most of these national rules on prior notification have not foreseen in exceptions, so in exempted categories, which means check beforehand if, for example, you allow this person a workation in Italy, whether you have to make a posting of workers declaration in the Italian system. Check it. And in some of those systems, like Austria, Luxembourg, and the Netherlands, you need to upload additional documents like the A1. So for some countries, you need an A1 in order to comply with the Posting of Workers Directive. Voila. Which brings me to the last slide with no text anymore. I see I kept the correct time frame, voila, thanks to a rather large clock which has been installed. So I'm completely open to all of your questions or remarks or feedback or whatever you might have.
I'm very glad that you listened to me, Bruno. So we have now the floor to you all. If you want to ask, if you want the floor, this is possible. If you want to ask a question and you do not want the floor, you can write it down in the Q&A. Bruno, we have already some questions, and I wanted to start with Tim De Wilde, who has asked for the floor, I think. He will be allowed to join immediately. But for those who want to leave, many thanks for joining us. Slides and the presentation itself will be made available. This was the first presentation of the Innangard executives. So we hope to see you again next time, but now we are going to continue with regard to the Q&A. And Tim, you have the floor.
Hello, I am Belgian. Well, I have Belgian, I have a residency in Belgium. I'm Belgian nationality, and I work for a Belgian branch of an American multinational. But since my wife is Mexican, I actually work from home from Mexico for 6 months a year up to now. So is this considered a posting as well?
Well, yes, we do not have a bilateral agreement with Mexico. You work for the branch in Belgium. I suppose you're on the Belgian Social Security.
Yes,
and it is
Belgian legal entity.
Yes, Belgian legal entity, which means it is effectively a mission to a country with whom we have no bilateral agreement. So then the Belgian national legislation applies. And the Belgian national legislation says, if you are going to be sent, in the very large sense of the word, to Mexico for a period not anticipated to last longer than 6 months, which is your case, you automatically remain covered in the Belgian scheme for employees, which means during your work in Mexico, your employer will continue to declare you in the Belgian scheme, and you will maintain all your Belgian social security rights as if you were still working in Belgium. There is, however, an important point which you have to address or not, which is health insurance.
Yes.
In a sense, you retain exactly the same rights for health insurance in Belgium. So if you go to a doctor in Mexico and you get a ticket, you can send this ticket to your Belgian health insurance fund. But be aware, first of all, this ticket must be very clear. So in English, what kind of doctor is it? And what exactly did he do? Because this your Belgian National Mutuel, Ziekenfonds, will have to assimilate the situation to a Belgian situation. And they could say, okay, we assimilate it to a visit to a general practitioner, which means whatever you paid, it's very possible it's a private one, and you paid, for example, the equivalent of 70 euros, well, you will get the classical reimbursement in Belgium, which is a bit over 20 euros.
Okay.
So this means it is possible, if whatever happens to you in Mexico, and you get a very large bill, way larger than it would have been in Belgium, that there could be an enormous difference. So in your case, being it is 6 months, I think an additional private health insurance would be advisable, as we have no bilateral agreement. Secondly, there's the question, what does Mexican National Social Security say? By working in Mexico on the Mexican soil for a Belgian employer, will this trigger some obligations into the Mexican system? That I have no idea of, but it's something you should be aware of and that should be checked in a sense. Is there a liability to Mexican Social Security, yes or no? Hopefully the answer is no.
Okay.
In your case, last point, and I think it's interesting to have a look at the website I mentioned, www.socialsecurity.be, because you can also opt not to continue Belgian classical Social Security, but to go to the overseas Social Security scheme. And in your situation, it could be a very interesting situation because the coverage is way better and it's adapted to exotic situations. So have a look at this part, the overseas Social Security scheme.
Okay, thank you.
I can see that there is a question related to that. You've talked about Mexico, but I presume that Brazil is quite identical?
Yes and no. Brazil is easier because we have a bilateral agreement with Brazil, which means we can issue you not something which is called an A1, because A1 is it's European. It's called a COC, Certificate of Coverage.
And then there is a specific question with regard to Brexit, of course.
Yep.
The position with regard to move from or to the UK.
Well, Brexit is quite a complicated situation because in general, I gave a webinar just on Brexit. But shortly speaking, there is no really a social security issue with UK, because depending on the situation, if your situation started before the end of previous year, in that situation, the European rules will still apply. If not, it's a new piece of legislation which is called the Trade and Cooperation Agreement. And this Trade and Cooperation Agreement also has a protocol on social security where the rules are in fact identical to very similar to the European regulation. There are some differences, but nothing really major. So social security wise, Brexit has not created enormous problems because there was a new piece of legislation that regulated the situation. For a specific, because your question was very general, the position with a move. So it's very general. Of course, you are free to ask advice to whatever or to us, giving us more details on what exactly your move and in which circumstances it would be. We would give an advice as well.
I have seen another question. Where can an employer find more information about what to do in France, Austria, Netherlands, and so on? Is there a good website on European level where all the rules can be found, or we again just go and surf to the Belgian Social Security site?
No, you will not find much on the Belgian Social Security site, but I would advise you, first of all, to go to the site of our French colleagues, because the site www.claiss.fr, the CLAIS in France, it's the Centre des Liaisons Européennes et Internationales de Sécurité Sociale, which is the abbreviation of the CLAIS. There you will find country fiches on, with a very nice summary of all the social security schemes in Europe and the countries which have concluded agreements. And of course, on the European site themselves, there's also quite a lot of country fiches on what exactly to do. But if you want to go to a more detail of how exactly an employer can register into the French system, for example, this is very national. There's a very nice piece of European legislation called the Single Digital Gateway, which obliges every member state to make all its national information available. So if you go to Your Europe, in one word, you type in Google Your Europe, then you're getting to a European website, which is an excellent portal and starting point to find out exactly what you have to do in all these different member states. So Your Europe.
I think, Bruno, that it was too clear because we do not have any more questions. We still have one? Okay. Yeah. Boris wants to be a bit more informed about how you can handle the difference between EU and non-EU, or Belgian and non-Belgian residents with regard to telework. He's very interested in that part because you've given the answer, of course, but it's not very sure already that it's that easy to make a difference between Belgian and non-Belgian people or Belgian residents.
Yes, I think the question, I've only outlined the question, not giving you the answer, because it's not social security, it's not something we are competent for, it's something on labor law. And it has to do with discrimination or no discrimination. And in fact, rephrasing the question goes as follows. You say, I don't want to give telework to my non-residents 25% or more, because I do not want to switch of social security. For the Belgian residents, in my example, it's a Belgian employer, it makes no difference for social security whether you give them 100% telework or not. So is it then possible to say, I draft a policy saying your Dutch residents can have a maximum, for example, of 1 day a week of telework, which is 20%. This means you make a difference between the Belgian residents and the Dutch residents, which is perhaps a discrimination. Now, what is a discrimination? A discrimination means a different treatment between two situations that are the same. But the first question is, working in Belgium, workplace, and working and residing in the Netherlands, is that an objectively different situation or not? Because, well, very simple, the European regulations, they have a different treatment, whether you reside in another country, or you have an employer in another country, or you work in another country. So first question, I'm not going to give you more than a question, is this an objectively the same situation or a different situation? I don't have the answer to that. I have an idea, I have my personal opinion on that, but I cannot give you a professional opinion here. And then I say the second level, if in the first question to you, it is effectively a discrimination, then the second question is also, is it a direct discrimination or an indirect discrimination? Direct discrimination means on nationality, but you are not bothered with nationality, it's residence. So it's an indirect discrimination. Now, contrary to direct discriminations, indirect discriminations can be justified. And there the question is, these major impacts, these major changes caused by telework more than 25% in abroad, where the residence of the person is, are these consequences I've put on the slides, are they serious enough to justify this different treatment? Yes and no. It's an open question. I've asked it already to quite a number of people competent for it, and I did not give, first of all, I did not get a clear answer, and secondly, I got all kinds of answers. So it's still an open question, which I suppose one day or another will end up before a court, and they will decide yes and no. In the meantime, of course, you have to go for it. So I would say, for the moment, it says seek legal advice from people competent on this subject matter.
We have two other questions. One question is again with regard to A1s. What about an employee with a split payroll, 50% Belgian, 50% Dutch employer? How do you have to request an A1 document for them?
Okay, so situation, person works 50% on Belgian soil in the employ of a Belgian employer and 50%, I suppose, on the territory of the Netherlands in the employ of a Dutch employer. How do you have to request an A1 document? Well, you have to know where does this person reside? What is his habitual residence? If his habitual residence is in Belgium or in the Netherlands, that means he works more than 25% there, and the A1 should always be requested in the state of residence. Even if the state in the end turns out not to be the competent state, you always have to request it in that state. Which means if it resides in the Netherlands, resides in Belgium, well, you have to ask it in your place of residence, and in your case, the place of residence will also be the competent state. This means one or the other employer will have to comply with the rules of the other state. If your residence is outside those two countries, because it's possible, this person lives in Germany, for example, you still have to request in Germany the A1. But as you have two employers situated in two different member states, which are not your resident state, it's still your resident state that will be competent. So it will be German legislation. So in your example, exactly your question you asked, it is impossible to give you a clear answer because there's one element missing in the question: where does this person reside? But in general, ask the A1 in the place of residence.
Okay, we have two questions. I should have asked this one first because it's about discrimination. So is it discrimination if an employer terminates remote work for an employee because of changing regulations and unwillingness to give the same remote work rights to other employees? Again, it's of course an employment law.
It's excellent question, absolutely, because this will happen. Because now, today, remote work could be handed out to anybody without any consequences, because we are in this grace period of force majeure till the end of the year. But it's very well possible that here a person, for example, resides in France, now enjoys a lot of working from home, and that now the employer says, starting from the 1st of January, it's 1 day and nothing more because I don't want French Social Security. And everybody else says, oh, all the Belgian residents, you can work whatever you want. This is something that will happen. And the question is it a discrimination? Well, it's still the open question. I cannot give you an answer for, because my employer is only competent for Social Security, so I am too.
Yeah, and I think we will have to wait for courts to decide.
Well, first of all, everybody in the juridical business, all the lawyers and everybody, consultants and everybody else, they will get a question.
Yeah.
So they will have to advise their clients. And of course, everybody will have to make the juridical analysis and come to an answer, an advice. But probably, I think, in the end, this will lead to one or another court case.
Vera Leroux has made a remark, not really a question, but more a remark, that according to her, making distinction between Belgian and non-Belgian residents would, in her opinion, entail that you aim at a result that treats people who find themselves in a different situation in the same, and I presume that she wants to say in the same way. It's a difficult one. I can't say that I would be very happy to answer in 3 minutes that question if a client would give me a call and ask what to do with it. Yeah. You can try to avoid things by saying that you can work at home as long as it does not change Social Security regulation. That's a rule that applies to everybody, but of course, people that living elsewhere are much more affected, so it would definitely have effect. I think that the questions that we have all questions. That's the chat. We have 5. I don't know why it remains red, but it's more that people thank you for your very good presentation. I think it's a very good hour to stop. We stay online for as long as it needs, but we're going to end this presentation. Bruno, as always, it was great. We had many reactions that it was very interesting, very clear, and very, you can see people with the thumbs up.
Starting to blush.
This was the first seminar of Innangard executives. Next, there will follow others. Stay tuned and have a very nice afternoon. Bye-bye.
Bye.